¿En streaming?
Sí.
¿Y tú vas a poner en inglés? ¿No? Sí, claro. Entonces, buenas tardes. Les damos la bienvenida a la primera sesión del seminario en International Discussions on Procedural Law. El título de la sesión es When Confidentiality Defies Procedural Law, Ideas for Adaptation. The whole seminar will be conducted in English. We have first, we're gonna hear Professor Thomas Falk. Thomas Falk studied law at the University of Chile, obtained a master's degree in 2014 and a doctoral degree in 2019, both from the University of Bonn. His doctoral thesis, Control of Information and Confidentiality in Civil Procedure, was published by Moore-Siebeck in 2020. Since 2021, he has been an assistant professor of procedural law at the University of Chile. He will give an overview on the protection of confidentiality in judicial procedure in our country. And then we will listen to Professor Lina Hornkoll. Professor Hornkoll, after having earned a master's degree from the College of Europe in European Law and Economics, she is currently an assistant professor for European Law at the University of Vienna, and she will offer a view on confidentiality protection from the perspective of EU competition litigation. So, I leave you with Professor Fox.
Thank you very much. I have a PowerPoint presentation. I will enable now. I hope you can see it. First of all, I want to thank especially the Lena Hornkoll for accepting this invitation to exchange these ideas about civil procedure confidentiality here in Chile. We have other activities also tomorrow. So thank you very much for your presence here. It's something very special for us here in Chile to have this opportunity of see how of somebody who knows all the systems to be able to explain them to us. So thank you very much. And I also want to thank Professor Nicolás Rojas for moderating this panel. And especially also my students and the interests of the students very important for us, because these are activities that I think focus on topics of the procedural law of the future. So it's very important that there is also an interest from part of the students. So thank you for being here. And I will start with. I will give a general overview of the problem of confidentiality in the judicial process, a conceptual overview. I will not refer to any specific civil procedure system. It's focused more on civil procedure than on criminal procedure, but it's a general overview on the problem of confidentiality and how this problem can be described nowadays. So I will suggest, first of all, to see the judicial procedure as a source of information in this context, not as a procedure to decision-making process, not only as a decision-making process, but also as a source of information. Then I will show how the informational control is a new function of procedural law. Then I will show the basic risks, the basic measures. I will be very short because Lena will talk about it. And then the problem of how to decide about confidentiality protection, the interlocutory procedure, procedimiento incidental, we would say in Chile, about confidentiality. So first of all, what's the problem? What's the core problem here? I think there are two developments in procedural law that generates a problem, and this important or this increasing number of issues with confidentiality in procedural law. First of all, the expansion of the scope of procedural access, gathering and access to information with discovery and disclosure mechanism. This is something also we talked with Lena about the new directives, the European Union that all have some rules on disclosure, and they're expanding, like the possibilities of disclosure are expanding the mechanism. And it's not only in the European Union, also national systems. Also in Chile, we are discussing about broadening the access of information of the litigants before the proceedings or before evidence taking. So it's one of the developments of recent procedural law, and this turns the judicial procedure into valuable sources of information. This is the first thing. And the other aspect is the expansion of transparency and open justice requirements. The ideal of broad accessibility to the procedural information, of course, for the parties, but because it's essential for them to exercise their procedural rights, but also for the general public. Because of, and there are very justifications, open justice, accountability, the oversight of the citizens of the justice, of the judiciary, and so on. So these two elements, these two expansions of rules of information gathering, more information to the decision-making process, the decision-making process, and then the idea that this information must be broadly accessible. The idea of publicity and transparency generates this phenomenon of a judicial procedure that's a broadly accessible source of information. And this creates problem. What way is this a problem? It's a description one could think. Because a description is not really anything problematic. It's like almost an obvious thing. But there is the context information society. The best way to describe the information society, I think, is referring to, not to the quantity of the information. It's not a good theory. There's more information that there were before. There may be the case, but the best theory, I think, is that contingency of modern society. Contingency, everything can be different. When everything can be different, law can be different, life can be different, economy. You need decisions. There are not fixed economy or fixed law like in older times. Everything is contingent, and that there's a bigger need or larger need to, or a lot of situations where you need more decisions in business and government, legislators, and so on, private career choices, private choices, there are choices everywhere. And this proliferation of decision-making necessity requires also more information for good decision-making. A good decision is an informed, a rational decision. So there's a increasing demand also to information everywhere. So the increasing demand for knowledge and therefore interest in exploiting all available sources of information, and therefore the judicial procedures become increasingly interesting as sources of information for purposes different from the proceeding, different from the reason that's justified the gathering of information in a procedure. This is a little abstract, but it's clear if we see examples like mass media is interesting in information of procedures, especially, for example, a Johnny Depp trial. We saw how interesting that can be. The government agencies need information for regulating activities. Businesses, very important in Lena's line of work. Business is very important for information on markets and regulators, potential litigants for future litigation, journalism for uncovering harmful activities, and so on and so on and so on. Information that is gathered for procedural purposes can be used, will be used, and can be interested in all different contexts, in very different contexts. That's the point of the problem, and that was not like that 100 years ago, or even maybe 50 years ago. So what's the crucial problem of judicial procedures? The information gathered and made accessible for procedural purposes can be unpredictable and non-procedural effects and uses. And the traditional law is usually not equipped to handle problems like this. Handle problems not related to the decision-making process itself, but to the fact that the decision-making process gathers information in a way that turns it into a valuable source of information, which is prone to misuse by parties or by third parties. So that was one of my points in my doctoral thesis, is that there is a problem of non-procedural effects of procedural information flow, and this can be viewed as a shared problem, like in comparative law, like a tertium comparationis for functional comparison of procedural law across systems. And so we can identify in each procedural system rules that regulate the risk of non-procedural effects of giving access to information related to the procedure. And protection of confidentiality, I didn't mention confidentiality until now. The problem of confidentiality is one of the problems of this broader problem that I called information control as a new challenge for procedural law. You can call it confidentiality in a broad sense. I don't care what you call it, but that's the problem, that the non-procedural uses and effects of procedural gathered information. So what are these risks? What are these risks regarding the procedure as a source of information? The first one is the idea that disclosure, like the confidentiality protection in a narrow sense. Procedural disclosure clashes with non-procedural norms on secrecy and confidentiality. Privacy, professional secrets, business secrets is very important in your field, right? And so on. So there are secrets that are secrets not because of the procedure. Like there's a confusion. You can say that a confidentiality issue is an issue where the information is ordered, the confidentiality is ordered by the tribunal. But I'm not referring to this. I'm referring to secrets that are independent of the existence of a procedure, that are secret, and there is a risk of secret loss or secret revelation if you include or you introduce this information into the procedure. So there's a problem there. Procedural law has to figure out if then we dispense with the disclosure, we exemption of disclosure, or we try to include this information protecting the exclusivity benefit of the secret. So this is one problem. The other problem is the subsequent misuse of information. Not necessarily secret information can be used for other purposes or legal purposes. There we have reputational harm, commercial exploitation of information. This was an issue in Chile with a digital file that some businesses or people could harvest the information of the public digital file and sell it for a good price and so on. And there are other examples. I will not mention all of them. And then the third one is the risk of compromising the quality of the decision-making process. This is mainly a problem with media coverage. When there are concerns that the media coverage of some procedures can be used, can influence the parties, can be used to, can affect impartiality of the judges, and so O.J. Simpson case and this kind of problems. But also the witness protection type of problems, that some participants could be threatened, so they are not available for the trial, and this could affect accuracy of fact-finding. This is usually referred to in international treaties and also in comparative procedural law as interest in the administration of justice. That for the interest of administration of justice, we could restrict publicity or in general access to procedural information. So I would say there are these three risks we can see in all procedures, in all systems. We can detect these three problems, and then we can ask ourselves how the procedural law handles these problems, and if it's sufficient or it's not sufficient, or it's not needed to be handled by procedural law. It could be handled by substantive, like material, substantive law. For example, reputational harm. You could say the procedure should not care about reputational harm, and if some person illegally makes defamation or actions like that could be subjected to a different procedure, and it's a different problem. You could say this that it's not a thing for a problem of the procedural law. I will not talk much about the measures because Lena will talk about them. I just want to give like a few. The risk stemming from this risk can stem from the public or from another party or other participants. So if it's from the public, you can exclude or restrict the media publicity. Like in the O.J. Simpson civil case, they did that after they saw what happened in the O.J. Simpson criminal case. The exclusion and restriction of the physical public or public access to documents or files and so on. And they're probably more difficult to handle. Risks stemming from parties or other participants. There's the restriction of party access to information. That is very difficult because it restricts also the procedural rights of the party, the right to be heard, to prepare a case, to prepare a defense, to have access to the lawyer, and so on. So it's a tricky one. Lena will solve it, I hope, in the next presentation. The restriction on subsequent uses of information. That's another one. The most famous is order to maintain secrecy, or judicial order to maintain secrecy. But there could be other big communication. It's right to regulate the communicational behavior of the parties regarding protected information. It's another. You can combine those, of course. You can combine exclusion of the public with some restrictions of the exclusion of the public with some restriction of the parties regarding or some restriction on the parties to communicate about the protected information in the procedure. Another one is substituting the disclosure of confidential evidence with expert report about it. So you don't disclose the confidential information, but give the information to some expert, and then the report is submitted to a court or to a party. This is problematic because then the parties could be still interested in the actual information, so it might only delay the problem. But for initial stages of the procedure, it could be useful. And ultima ratio, preventive exemption from disclosure. You can say, no, the risks are too high, or the secret is too important. Like typically in the lawyer, in the client attorney privilege, it's the case where it's an absolute right. So it can be very useful information, but we will not disclose it because this secret is too important to be sacrificed for the information, for the purposes of the proceedings. And the last thing I want to talk about is, and probably the most difficult thing, is how to structure the decision about the control of information. And there I recommend to see two basic distinctions, two basic situations. The first situation is a party seeks disclosure from another litigant or third party who refuses, claiming a confidentiality interest or risk of misuse. So a party seeks disclosure, the other says no. And there is a problem, an issue, a confidentiality issue. And the other is a party seeks to introduce information to the proceeding, requesting not to reveal it to another party or to the public. So there are these two basic situations, I would say. And how to structure this issue, this dispute, this confidentiality dispute. I would say the best practice, I don't know if Lena agrees with you, you can then discuss about it. But this is the best practice. If you see a party seeks disclosure and another litigant party refuses, claim it a legitimate confidentiality interest or risk of misuse or whatever, one of the risks I just showed in the other slide. But first, there's almost in all procedures, I think, now plausibility thresholds to activate the disclosure. It's like a plausible claim. That's the first threshold. Before the discussion, before it's even necessary to discuss the issue. And then the movement has the burden to make the case that the requested information is relevant and necessary for the purposes of the procedure. The purposes of the procedure can be different in different stages of the procedure. At the beginning, it can be just preparing the case, for adequately preparing the case. Later, in the evidence and proof taking, it can be to be able to prove a statement of fact. It can be different. That's why, but the movement will make this case, and which presuppose reasonable specification of the requested information. And there are some discussions what's reasonable. You have to identify the items or the category, or it's there are different criteria, but this is the idea. And then the burden of the respondent to make the case that the request poses a legitimate concern of misuse of information or affects a confidentiality interest, depending on what he's claiming to resist the disclosure. And there also, and this is important, there also needs to be a reasonable specification of the risk or secret that is in place here, and a suggestion of an appropriate measure of information control, of confidentiality, a protective measure. Call it what you want. And then, and this is maybe the most important part, a balance of interests, a kind of proportionality triangle. And I think this formula shows how the decision making in this confidentiality dispute should be guided by. The expected benefits of disclosure must justify the cost and risk of disclosure. So there's in one part that benefits, and this is of course important for effectiveness of the claims, for truth seeking, whatever you want to call it, but there are values behind it, the benefits of disclosure. Must justify the cost and risk of disclosure, like the risk of revealing information or risk of misuse, whatever. So we have two parts, and it's a triangle because of the third part. You have also take into consideration the protective measures available and the restrictions they made, because protective measures have some consequences. They can restrict procedural rights of the parties, like a confidentiality we will see. It will restrict, for example, the access of the public to the litigation. So there are three interests involved in this: the interest in disclosure, the confidentiality interest, and the interest of maintaining the procedural rights and the public rights of access to information. And this is, I think, the formula or the core problem of all this confidentiality issues. I think it's enough. I wanted to make this point. We can make the same exercise for the other situation. A party seeks to introduce information to the proceedings, so it's had the burden to make the case for relevance, necessity, and also why a protective measure is needed. And we come to a similar formula. We don't have to dwell on that. And two typical problems. I would just want to mention two typical problems of like the problem of procedural overload. Maybe Nicolas knows a little bit about that. And the problem of who makes the selection of the concrete information to be disclosed. About the problem of procedural overloads, it's there are some considerations. Efficiency is one of the considerations to make. The burdens of reasonable specification is very important to be able to make a decision about this. And this is a part that's very interesting. There's a reference to the Federal Rules of Civil Procedure that the promotion of party agreements. In some situations, the parties will know better how to handle these conflicts than the court, and will be and the court does not have the time or the resources to do it every time. And so some systems, for example, here the U.S. American federal system of civil procedure imposes on the parties the burden to confer or attempt to confer in good faith with other affected parties in an effort to resolve the dispute about disclosure confidentiality without court action. So there's like a pressure to the party to not to burden the court and the procedure with every issue, confidentiality issue, but to try to solve it for themselves. And this is a big part, because in England we have similar rules. This is a big reason why this confidentiality issues are better resolved usually in the common law countries than in continental law countries. And the problem of who makes the selection of the concrete information to be disclosed, every option has problems. The disclosure, if it's a disclosure party, how do I control the disclosure party is really disclosing according to the court order? If it makes the judge with all parties participating, maybe sometimes. The point is that the parties do not know the information. So I cannot select, the judge cannot select with all parties participating. If the judge selects with the sole participation of the disclosure party, there's a problem of right to be heard. And in partial third parties, there's the problem what we are not, the parties are not convinced of the, or are not do not agree to the selection in partial third parties. That reproduces the problem. And maybe the best thing is the confidentiality ring. Lena will talk about later, so I don't need to talk about it. So we don't need the summary. You know what I said. If somebody is interested in the presentation, I can send it to them. And thank you very much for the attention.
Thank you, Professor Falk. So I leave you with Professor Harncroft. 2 minutes.
Das sind die großen Köpfe, oder?
While we do this, I can already say thank you for inviting me. we can kill this time. Yeah, thank you, Thomas, for inviting me here all the way from Europe to come here and talk about a topic which is very dear to me because this was my PhD thesis. So the balance between confidentiality and disclosure specifically, but then also more broader, this issue of confidentiality arrangements in competition law. And what I present to you today is actually, you're very lucky because the paper I'm presenting today is a Spanish paper and it's available open access. And you will get a link at the very end so you can look it up for free in a book. I haven't written it myself. I've written the paper in English and then somebody had to translate it to me because I still don't speak Spanish, which is something that I need to change, but you can read up on everything that we discuss about today. I will present you the only European Union rules that we have on confidentiality. And the only European Union rules we have on confidentiality is in the area of competition law. That dates back to the fact that the European Union is, I would say, a quasi-federal structure, which only has very limited competence to rule on procedural law. And competition law is one area where they can also regulate the procedures. And that's why they created rules in competition law for procedures and for confidentiality in particular. And it can be used a little bit as a model for other areas of procedural law. And I think competition law was also chosen as an area because, let's say, for practice, it is most important because, and I think that's my first slide, we have this clash that also Thomas talked about. We have a little bit of clash of interest where on the one hand, parties have a really, really hard time substantiating their damages claims. So the parties who file for competition damages actions in European national courts, they need information which they don't have. So they need information on calculating damages mostly. So they need business information from other parties, third parties, or the undertakings who have violated competition law on how they set their prices. So they need a lot of data to substantiate that, and they usually don't have that data. And the data I was just describing, so internal business data, is of course something that third parties, but also the undertakings who are the defendants in that procedures, they do not want to give out. So there is this clash. You have information asymmetry on the one hand, and then you want to protect the same information that people need in these proceedings. And we have rules on that in the EU on, let's say, law level. which is what we call directives. So in EU law, you can have two types of laws, regulations and directives. Directives are laws set on European Union level that are supposed to harmonize the member state system, but member states need to transpose them into national law. So this directive is only binding on the national legislator, and then the national legislator introduces the rules in national law. And when it comes to this clash of rights, the damages directive, which is the competition damages directive in the EU, says in the recitals in the very, very beginning, okay, confidential information needs to be made available, but it needs to be protected appropriately. So you see, the directive sees this clash. We need this information, but it needs to be protected. And the directive does this in a matter that Thomas was already describing a little bit, that there are conditions before asking for information, and the main conditions that is a condition that is available to protect confidential information is proportionality. So in the end, a weighing exercises between the importance of the information on the one hand, and then also the information that needs to be protected. And so you can see here that confidential information in general, but also the arrangement that can be taken for confidentiality plays a role in deciding for whether or not something should be disclosed. And here, as a rule, you see confidential information should be disclosed. So only when confidential information cannot be protected in any other matter should disclosure not happen at all. So that's the, let's say, ultima ratio outcome. When you cannot protect the confidential information in another matter, only then can it not be disclosed. Because what we should end up at is, that's also what the directives tells the member states, national courts must order the disclosure for all the information relevant, but then they need to have effective measures to protect it. And that's all what we have in the text of the directive on how to protect the confidential information. The directive only says effective measures. In the preamble, or what we call recital, which is not binding on the member states, it's just a tool of interpretation, the directive suggests a few measures. And it suggests redacting sensitive passages. It suggests in-camera hearings, meaning exclusion of the public and also and the media, restricting persons allowed to see the evidence. That's what we call a confidentiality hearing, but more on this in a second. And then also instructing experts to produce summaries on the confidential information. So you see here, the directive gives member states the possibility to disclose it. It says there are some effective measures to protect it, but the instrument itself does not give more information rather than this short list on how to protect it. And so the member states, they had to transpose this directive, and I just want to show you two examples of how member states dealt with that situation. And one example is Austria, where I'm located at the moment. And you see here, that's the transposing law, the English translation of the Austrian rule, which also has a list of very, very precise measures to be taken. More interesting for you will be the Spanish one, because it's also in Spanish. And you can already see here from the volume of the texts, not only that Spanish is longer in general than compared to English, but also you see much more detailed rules on how disclosure and the protection of confidentiality should take place. And Spain, Austria, and also Portugal, I didn't include it here, they are the very, very few member states who introduced such a list and who laid down in law the specific measures to be taken for confidentiality protection. In many, many other member states, most notably Germany, where I'm actually from, but also France, for example, Italy, what was introduced is what we call a blanket clause, meaning confidential information needs to be disclosed, but it needs to be protected. Please, judges, deal with it yourself. And the problem here is obviously that European judges are not used to disclosure at all. And since they're not used to disclosure so much, they're also not used to measures on how to protect confidential information. So in all these member states that do not have lists and measures such as the ones in Spain, for example, judges are a little bit left alone and they have to decide, okay, what protective measures can we install? The Commission, therefore, a little bit later introduced something that we call the confidentiality communication. And you can also look this up in Spanish. We have the luck in Europe that when there's a new EU instrument, it has to be translated in all the member states' languages. Same with the confidentiality communication. So what is that? A communication is a non-binding document by the European Commission, which is the European administrator in competition matters, but also in other matters of EU law. And they created this confidentiality communication because they saw on member states there are not enough rules on how to protect confidential information, and judges really are very inexperienced with that. So we are trying to help them. Very important to understand is that this is a communication that does not only deal with the issue of disclosure in competition law, but with all the competition law proceedings. So even in matters that do not deal with disclosure, normal proceedings, that this communication deals with. And also what is interesting to see is that this is a non-binding document. So it's just for interpretation. So member states courts can use this document to use it as a source for inspiration for confidentiality. And I will talk you now a little bit through these measures that the communication proposes. Because the first instrument that the communication proposes is the redaction of documents. You can see, if you can see that here a little bit on the screen, it's basically taking out of documents the part that you want to protect, which can be completely anonymized in the sense that there's really just like black color on it. But what you can also do is you do not have only anonymized, but also aggregated data. So you could have data ranges, for example, or other aggregations. And here, the communication stresses the issue of when and how redaction could be used. And the first big caveat for redaction is actually the question of relevance. Because what I've said in the beginning, you can only not disclose information if it's not at all relevant and it's a last resort to not disclose specific information. And the same holds true for redaction, because let's say redaction is a small form of not disclosure. It makes no difference whether or not you do not disclose the whole document altogether or the really, really decisive part. So redaction of information is only possible if the information is not relevant to the proceedings. So you need to have access to some documents, to some emails, and there should be some confidential information protected. But this information cannot be relevant to the outcome of the proceedings. Otherwise, it's only possible if, let's say, the interest in the protection really outweighs the interest in the information. And another caveat is, of course, the comprehensibility of the redacted document. So if you can redact, you need to still be able to understand the rest of the document. So if you ask for a redaction, you cannot redact the whole document, but only really the necessary part. And what the communication stresses is a cost-benefit analysis, and I think it's very important, because in big competition law cases, you could have truckloads of documents that would be relevant to the proceedings, and where you would need to have some redactions. And if you really have a lot of documents that need to be redacted, this takes a lot of time, and it is very, very costly, because somebody needs to do this, and at the moment programs are not able to doing it on their own. So if the costs are very, very high to redact a lot of documents, then you should rather go for another measure. And the measure that is, let's say, in the center of this communication, really pages and pages, is what we call a confidentiality ring. A confidentiality ring is a limit of disclosure to only a certain group of people. And what the communication distinguishes is, on the one hand, the installment of the confidentiality ring, and then also who can be included. So on the first level, on the installment, you need to ask yourself, okay, for which documents does this make most sense? And as reduction is not available for relevant documents, so documents that contain, for example, information on decision relevant data, this decision relevant data should be included in a confidentiality ring. And also everything else that is really strategic information so business information of undertakings should be included in this confidentiality ring, because it is less costly to set up a limitation of persons who can access the ring rather than have 20,000 documents redacted. And so for procedural efficiency reasons, sometimes it makes a lot of sense to have a confidentiality ring installed. And what is really interesting, and here the communication is very forward-looking, is they introduce rules on electronic organization of these confidentiality rings. That could be, one computer in the court's basement where all the information is stored, and then only specific people are allowed to access it. So that's basically the first level. Do we want to have a confidentiality ring? And then the question is, who can join the confidentiality ring? And here, there's really not a fixed rule on who can join the ring and who can access the documents, but you need to a little bit decide on a case-by-case basis who can access it. And there's, I would say, a different degree on persons who would be suitable here, and that's also what's in the communication. For very, very strategic business information, what the communication suggests is only giving access to external legal advisors. So the parties themselves are not allowed to see the confidential information, only their lawyers. They are represented by lawyers in this confidentiality ring, and the lawyers have also a duty to protect the confidential information vis-a-vis their own clients. They can give them a general overview. They can also give them estimates and aggregated numbers, but you cannot give access to this very, let's say, core strategic information that stays with the external lawyers. That's, I would say, the most, let's say, harsh version of a confidentiality ring, but it can be necessary in many cases, actually. Then you can have other external legal advisors joining. So for example, auditors or experts. So for example, if the confidential information relates to technical information, sometimes you need experts there because no lawyer can understand what the hell is going on. You need a technician there who explains to you what is going on. And then, especially if the confidentiality is a little bit mitigated, you could also have company representatives there. And here the communication distinguishes between, of course, in-house lawyers, means that many, at least global companies, have their own legal departments. And instead of having somebody there from the parties who really make strategic decisions, they bring the company in-house lawyers. And something else that is proposed is what we call a Chinese wall or a clean team, meaning that within the parties, within the companies, you need to sign confidentiality agreements, and you need to shield the rest of the company from the people who can access the confidential information. So these are all, let's say, possibilities, and not every confidentiality ring looks the same. And also, even in the same confidentiality ring, you can have different, let's say, grades. But you need to decide on who to include in this confidentiality ring, and that could mean excluding parties altogether. And then I will just pinpoint you very quickly to a few other measures. The one is also the experts, as Thomas mentioned. So what you cannot have is an expert intermediary, meaning that there's only the expert who can look into confidential information and not even the court anymore. That is not allowed in EU procedure law, because you always need to have the court witnessing the evidence themselves. But you could have experts in a supporting capacity, so for example, to create non-confidential summaries. And what this communication also delves into, and here only an overview, is also the confidentiality protection during the whole process. So basically introducing a confidentiality ring already in the written pleadings phase, but also excluding the public, limiting access to the court files and also service of judgment and publication of the decision only to the confidentiality ring, should that be necessary. And I think the last slide of my presentation here is, of course, confidentiality can also be relevant in other areas of damages action in competition law. But what I tried to explain to you today with this communication is specifically, between the parties and third parties, what also Thomas mentioned, in these business proceedings, in any kind of business proceedings, be it competition law, be it IP law, be it data protection law, all of this, you can find this instrument giving you ideas, or giving the court ideas what could be done regarding confidentiality protection. And as I said, if you want to read that up, you can read it up in Spanish, open access, and Thomas can send it to, I think, all the participants. And with that, I say thank you for now, and welcome to the discussion.
Thank you very much.
One point.
Thanks to Professor Folk and Professor Falco for their presentations. I have a question regarding your last slide, things that you could expand on. What happened to data gathered by the competition agency or during the sectional?
So that in the damages directive itself, we have the dedicated article on information coming from the competition authority. It's Article 6 of the damages directive, which lays down rules which information of the competition authority needs to be disclosed. And there are three categories. There's the white list, the gray list, and the black list. The white list means so everything that's not in the gray list or the black list, also the competition authority needs to disclose. So usually, competition law is enforced by public authorities, and when they enforce it, they have a lot of information on file, and they have to disclose that to any third party, any party who want to go for damages action. So there have also been court judgments on this interpretation. Now there's this white list that anything that's not specifically protected needs to be disclosed also by the competition authority. Then there's something we call the gray list, and that's a list of documents that during proceedings, the documents are protected. So if there's an ongoing proceedings of a competition authority, then the competition authority do not have to disclose the documents while the proceedings are ongoing. That's the gray list. So during these proceedings, no disclosure. And then there is a blacklist, means that these are documents that can never be disclosed. And that are documents, on the one hand, leniency applications. So a leniency application in competition law is usually you have a secret cartel. So let's say middle managers meet in a back room and they discuss prices. And then the competition authorities usually have a program where one of the cartelists can go to the competition authority and say, hey, we have cartelized our market, we have had these agreements, and bring this forward to the authorities, and for that they get a reduction of the anti-competitive fine. And for that information that can never be disclosed from the competition authorities to the parties, also settlement submissions is the same. If you want to settle with the competition authority, meaning if there's a proceedings, and then you settle with them, so you negotiate the fine a little bit for what information you give, that can also never be disclosed.
And this gray list and black list also applies to like appeals to
Yes.
European competition decisions when they go to the
Yes.
European Court of Justice?
Yeah. that applies throughout the, let's say, procedure at EU level, but also member states. So member states, competition authorities, and the EU Commission.
Yes, I have a few questions for Lena. About the confidentiality rings, to install for the confidentiality rule to be a reliable tool, you have to assure the compliance with the non-disclosure agreements of the members of the confidentiality ring. And this seems to be, I remember that in the German discussions, they hate this. They don't trust the lawyers. The Germans rather trust the judge to be the only one looking at the information than showing it to the lawyers for them to it's different. In the common law, it's easier because of the content of court, powers, which are very effective and very draconian powers that are probably unconstitutional under many continental European countries. So that's, and of course here in Chile it's the same question. How can we assure that this confidence, because it's easy, or other way around, it's difficult then to prove the leaking of the information and to construe something to find the responsible person. So that's one of the issues with the confidentiality, with non-disclosure agreement in general, and with, I would say, confidentiality rings especially. Maybe the same question: how because between lawyers and parties there are always loyalties, and how external has the lawyers be so we can trust this confidentiality, this confidentiality ring? That's one question. The second question is about what you said, that this confidentiality rings could stretch over the whole procedure, right? So even to the judgment. And it strikes me always as extreme that a party can be bound by a judgment the party does not, maybe not understand, because it does not have the information that was crucial for the decision. Because when some information is part of the judgment, it's usually, if the procedure went well, it's usually because it's crucial for the decision. And so to have like a redacted judgment, so just the lawyer of the party can see it and maybe explain it in a way, but the party itself, or the decision-making representative of the party in case of organization, cannot see all the, and possibly not understand why it lost the case, because the winner doesn't care, but there's always the loser who is the legitimation problem, the legitimacy problem there arises. How do you see that problem? Because I understand it in the early stages. In the early stages, you don't know what's relevant. There can be information, there can not, and there we can have confidentiality rings that see this is relevant for a case, this is not, and then the party can make decisions how to go about the case further, take it to trial or not, to settle, whatever. But the judgment, it strikes me a little extreme from the point of view of the right to be heard, and of the right of the parties to understand the judgment, understand how law is applied to them in a general way. So I think with these two questions.
All right, maybe the first with the assurance of compliance. So what I've not presented, but that's in the directive itself, is that the directive mandates member states to create sanctions. So sanctions by law on violation of confidentiality. And so what the member states have done is either criminal or quasi-criminal sanctions if somebody would violate these confidentiality arrangements. That can relate to fines, that can mean that a lawyer loses their license because they have maybe repeatedly, violating this obligation. Also, at least in Europe, it is that lawyers are generally part of the what we call administration of justice, meaning that they are not part of like the judiciary, but they are let's say an institution in the legal world, and so they have more duties as just like anybody. And so because they fall under specific regimes, these regimes now include sanctions that, okay, if you violate a confidentiality agreement from confidentiality ring, X, Y, that happens, you have to pay fines, you have to pay damages, you lose your license, and so on. And what actually happens now in these first proceedings is most of these confidentiality rings are indeed organized electronically. So electronically, either in the courts or sometimes it even works online, and there you can really, up until the second, and also see who has access what information when. So it's also really easy or relatively easy to figure out, okay, who has what information, and if some information is then passed on, then you can more easily find this out. And then how external lawyers should be, it just means that outside of the company. So there is actually this relationship of not being employed with the company you represent. So really a legal mandate, so to speak, because only then does a lawyer fall into this special regime of administration of justice, and all these rules apply. And then, yeah, you mentioned the stretch over the procedure, and of course here again, there's not a blueprint for confidentiality protection in all of these cases. So you need to look on a case by case basis, and of course, protecting the decision itself, which is possible under the communication and in many member states now, is also only a last resort issue. And here, what is usually be done is that the decision includes, the methodology to calculate the damage, because usually this resolves around the question, okay, data you need to calculate damages. So the numbers, the numbers of, for example, products sold in another company, how much these products cost, and so on. So that is redacted, not even redacted. Usually you have aggregated data ranges. So you say, okay, this company, for example, sold 2 to 4 million trucks in a volume of 50 to 100,000 euros, and so on. So you have these aggregated data, and then you have the methodology, so the econometric formula on how this was calculated. This is in the judgment, and this makes it not 100% understandable, but at least, shows the parties that the numbers do not come out of the blue. But even in that situation, it will be limited for the very, very extreme cases. What the communication includes is also a rule on the time frame of confidentiality. So it says that some information will always be confidential, and what everybody always mentions is like the formula of Coca-Cola will always be confidential. You will never have to disclose this, and this will always be, protected. But the prices of trucks you sold 10 years ago today is not confidential anymore, or the price of whatever product. So it could mean that during the procedures you have a confidentiality ring, but then competition proceedings take, 10, 15 years sometimes, and then in the end it's not protected anymore.
It's probably business secrets don't last that long as valuable information as like industrial secrets, like the Coca-Cola, that's always valuable.
Are there any questions from the audience?
Hello. I have two questions related to confidentiality rings. The first one is how common are the different compositions? For example, how common is the access to in-house lawyers? And the second question is, if some lawyers have access to these confidentiality rings, how can they use this information in an argument, for example?
So I would say these rules are relatively new. So everything I can tell you is like, I would say 1 or 2, maybe 3 years of practice, because the damages directive is from 2014, the communication is from 2020. So that only affects the very, very new proceedings. From what I've seen while working in practice myself, and also some of my friends are judges, they say that you have in every proceedings, you have different degrees of a confidentiality ring. So you have, or I would say, different layers. You have some information only the external lawyers can see, some the experts, some also the parties themselves, company representatives. Usually, in all these competition cases, the issue really resolves around calculation of harm. So how much harm has occurred? Has the harm been passed on to another distribution level, and so on? That is usually very strategic data, so you have more confidentiality rings that only allow external lawyers. And whether or not these rules are even legal has not been solved yet. There has not been a case at the highest European Court, the European Court of Justice, which will for sure one day have to rule on the matter whether excluding parties from proceedings is even legal from general EU procedural law values. Even though we have these rules, we don't know if that's actually will be the case. Maybe then somebody will buy my book and then they will discuss it. Actually, let's say also another European court, there's a case ongoing just about this question. So at the EFTA court, which is the agreement between the European Union countries and then the countries in, I think, Liechtenstein and Iceland and all of these surrounding countries, they have a question just like that. So bear with me. In a year, you will have a decision. And then how to use that is, as this cannot leave, this circle of external advisors, what happens in the end is that it's only the lawyers and then the economists fighting about, okay, they fight anyway on which methodology to use, but then also what not, on what they can include in the data set. But usually this goes on between the lawyers and the economists, and advising clients myself in that matter, you can also see that clients don't understand anyway what's happening there. So if you would have to try to explain to a client how an economist uses a regression model, that would take you weeks. So usually, at least how it works in Europe is that clients in that matter trust their lawyers, or they have to trust their lawyers. And even as lawyers, I did, as you heard, a double degree in law and economics, but even I have a hard time understanding regression analysis in depth. So in the end, we are a bit the victims of the economists. They have to, tell us, okay, this is actually how the overcharge has arrived.
Thank you for the presentation. I have a question for Lina and also for Professor Vogt. To Lina first. My question is, we are talking about disclosure of evidence, but in that part of the regularity cases, is the judicial files open? I mean, because there's a difference between disclosing the evidence from one part and from other part talking about disclosing the writings of the parts, right? The allegations that they make. Because I'm asking this because even though maybe we are not disclosing anything about the evidence, but how can this be a problem when in the writings the parties are referring to the evidence. So in a way, they are exposing the evidence and which are the limits of this. Maybe it's not that an important question because all the procedure is closed. I don't know that, but I think it's maybe something that can be an issue. I don't know if that's addressed anywhere. That's my question to Lina and to Professor Vogt. In the presentation, you talk about, you made a comment, really low-key comment about how the procedural law maybe is not addressed to take care about the problems on the reputation of the parties. We could say that, but I want to know maybe your poster about this, and if you really believe that, like, procedural law is not entitled or needs to be take care of the reputation of the parties. In civil law, even in other types of procedures, like, of course, there's penal, criminal law, and it's more complicated, but okay, only in civil law. We are ready to say that it's not a procedural problem, and maybe that's something we can say, and it's part of the risks of introducing into a procedural civil problem, right? But I don't know, that's not a question.
So the distinction that the directive makes is that all these rules in the directive, they are only on disclosure of evidence. But this communication that the Commission has drawn up, that's about all the procedure. So it does not only relate to disclosure of evidence. And that means that, you know, in the writings of the parties, that was slide 1 on to the end, the writings of the party, the service of judgment, all of this, if necessary, you know, the confidentiality rings should expand to that. So while disclosure of evidence, that's what the directive is a little bit about, this communication is really a nice blueprint that you can use beyond competition law, because it shows you all the different possibilities, you know, from start of the proceedings until the very end, how to protect confidential information. And of course, you know, in competition law, it's all about business secrets, but you could have a similar discussion on, you know, national security when it somehow concerns, you know, IP rights or artificial intelligence, all of this. Or you could talk about personal data protection, your personality rights in other kinds of procedures. So, and this is actually, the paper is a little bit about explaining the communication, but also how it can be used beyond competition law through the whole procedure.
Yeah. Okay. Thank you for the question. When I talk about the risk of informational misuse in opposition to risk of revelation of or loss of a secret, it will probably always be an area of procedural law of prevention of illegalities of other kind. It's very clear in witness protection, where situations where you are preventing harm to a witness, or threats to a witness that in itself could be a crime, and you try to prevent it, of course, to protect the witness, like the life and the well-being of the witness, but also to avoid that this affects the decision-making process. So there's a large part, or it's a question of the future, if you may, if procedural law should prevent and this kind of measures should also be used to prevent, like in witness protection, it's a specific case to prevent for illegalities of other kind, of criminal or civil damages, or like with defamation cases or something like this. Now you asked me about my opinion, which it should be. I hate this question. I like to show the overview and the terms of the discussions rather than take a position. But if you're pressuring me to do it anyway, I would say that if there are rules like this, they should focus on foreseeable risks of illegalities. Of course, because any other issue would be, if if we talk about proportionality, other limitations would be competing with the benefits of publicity, of transparency, of open justice, and of procedural rights of the parties. So I would say that if it's it should be an issue of procedural law, but to a minimum reduced to foreseeable risk of informational misuse, so that a judge can evaluate it. So it's not like a far-stretched risk. In every procedure, public procedure, there are risks of defamation or misuse or embarrassment and all this kind of problems. But just the possibility should not be enough to order some restrictions of publicity or to the procedural rights of the party. That would be my take on it. Any other? No.
Okay, so first of all, thank all of you for your presentations. I have a question regarding the costs and benefits evaluation you mentioned at the beginning of your presentation. Could there be a space in that analysis for like a sort of, I don't want to say distributed justice, but like, is the relevant market's structure relevant to that assessment, and is market power of the parties relevant in such a way? Or would that be like infringement of equal treatment between the parties? Like, could there be space for such an analysis there? That's my question.
Yeah, I mean, as the communication doesn't mention it, but just from how I would interpret it, it's not, especially in competition law cases, not completely out of the scope to take into account, you know, the financial backing that big companies have. So we talk about, you know, anti-competitive agreements a lot, but all these rules, they are also applicable in, you know, monopolization cases, abuse of dominance cases. And then you have a big company who is abusing their market power, and then other companies who are harmed by that behavior maybe want to ask for damages, and in that situation they need disclosure. And maybe these companies who are harmed, they are very small, you know, small, medium enterprises, so they have less financial means to go for procedures, but they are now, you know, the examples are always the Google, Amazon, Facebook of this world. And financial capability of, you know, dealing with reductions, dealing with confidentiality rings, that is a big issue, and that is mentioned there. So you can easily make this argument that, you know, there is a company who has a lot of financial backings. You know, I worked for a big US law firm at one point. We were representing one of these big tech firms all the time. So we always knew how it went. We were 20 lawyers in our team, and then there was one person in the competition authority who dealt with the case, one case handler. So there is this, and there's a very, very nice paper about it. It's called Spamming the Regulator. It's about somebody from the European Commission who wrote about how they are overrun with like economists and lawyers, because all these big firms are represented by a bunch. They have all the money. So this is taken into account general in EU competition law and procedures. So I'm sure this can also be relevant here.
Well, I'd like to thank Lina and Talk and all the public for joining us here. Thank you very much. Have a good night.
I can send you that paper. That's excellent.